My name is Sivan and I'm a litigator. I'm a commercial litigator, and what I do typically is intellectual property litigation. And trade secret is one of those topics that is ever expanding in the law. And recently we had a few enormous jury awards for misappropriation of trade secrets. So I think it is an increasingly important topic. And what I'm going to do today is talk about it in a fairly introductory level, because it's a huge topic. And when you talk to a group of people that are in developing different technologies in possibly different industries, it's very hard, to get into the nitty-gritty. And it's really a topic that has to be tailored for your own company. But what I do hope to do today is to equip you with an outline of the factors that you have to consider when you develop your customized trade secret protection plan. So I hope that makes sense as my goal for today. And if it's too obvious, I apologize. Hopefully you'll get a nugget or two from this conversation. So, you guys are all in the business of developing some technology. So it's not very far-fetched or a stretch to say that IP information is absolutely your most valuable information. And there's little doubt that protecting this information is critically important to the very existence and future of your companies. So today we're going to talk about one way of protecting your IP, trade secrets. That's one vehicle, right? And I think the initial question is to patent or not to patent. We already know that one legal vehicle for protecting IP is a patent, right? And we're not going to talk about patents because that's a huge topic by itself. But we all, I assume, generally know that when you patent an invention, the law gives you essentially a monopoly over practicing this invention for the term of the patent. So no one can practice this invention without your permission, without your license, right? But it's also true that not every type of valuable information could or should be protected by a patent. So that's the first thing we're going to talk about, patent or not patent. So first of all, some information only, oops, I jumped the gun. Some information only remains viable when it's patented. Why is that? Because, and this is quite rhetorical, so forgive me if it's banal, but when you patent a novel invention, you basically give a recipe of that invention to the world, right? The patent is a document that shares with the world your inventive process and reduction of practice, and you tell the world, here's my invention, take a look. The deal that you get with the law when you patent something is that you have monopoly over practicing this invention for the term of the patent. Nobody can do it without your license. But when the patent expires, society gets the benefit of your invention forever for free, right? So that's the deal with patents. A super good example of that is a guy named Horace Golden, who was a celebrity magician in the 1920s. And he's the one who came up with a magic trick he called sawing a woman in half. Of course, it had to be a woman. In 1923, I think, he patented his invention. So obviously he has a patent with illustrations of where the lady's legs are going so she doesn't actually get sawn in half. A few years later, the Reynolds Tobacco Company had an ad campaign where they published illustrations from the golden patents, and the witty slogan was, "It's fun to be fooled, but more fun to know. Camel cigarettes, no tricks, just better tobacco." So Golden sued Reynolds for unfair competition, basically saying, hey, you're using my secret trick. And the New York court sent him home packing, dismissed the complaint. Why is that? Because Golden patented the invention. Golden made the rookie mistake of choosing the vehicle of patent to protect his IP. So when Reynolds Company published pieces of what is already a public record, there's no problem with that. It's not patent infringement because the cigarette company is not practicing the invention. They're just basically republishing what is already in the public domain. So clearly, some information is only valuable when it's a secret. And it should be protected via the vehicle of a trade secret, not a patent. Another, super traditional example is the Coca-Cola formula that for many years was kept as a secret, and that's probably because it would have been really hard to enforce the intellectual property via a patent, but that's another story. So one category of information is information that only remains valuable while secret. The second category is quite obvious, and that is information that needs to remain secret while you're working on a patent, right? So while you're working on a patent, you have to keep your research or your technology secret until you get a patent. So during that period, you will have trade secrets. And number three is, for whatever legal reasons, you have valuable information that is not in the public domain, that for whatever legal reason simply cannot be protected, or for whatever strategic reasons, like the Coke formula, you wanna refrain from putting the recipe out there for the world. So the first thing you're going to consider is what is the best vehicle. But assuming you have something secret that you must protect as a trade secret, what is a trade secret? And again, this is a legal term. It is defined by both state and federal law. We don't need to go into the legal definitions of either. It's enough for you to know that Arizona, like 48 other states, has a version of the Uniform Trade Secret Act. I think New York is the only exception to that, with somewhat different version. And the federal Congress finally in 2016, after years and years of lobbying, passed the Defend Trade Secret Act. So now we have trade secret protection in both federal and state level, and both of those legal vehicles say pretty much the same thing. A trade secret can be any type of information that meets two conditions. One, it derives value from not being generally known. It can be any type of information. It can be financial, technical, engineering, economic, business, marketing, what have you. And it can be in any format. It can be formula, code, design, drawing, list, process. It can be an actual chemical material. It can be anything. But it derives independent economic value from not being generally known. And then that's critical. The owner of this information takes reasonable measures to preserve that secrecy. So let's break this down, because this is really, really important. And I'm gonna give up the animation. The information has to actually be a secret. If this information made its way to the public domain because you made no effort to keep it a secret, you have no secret and no protection if somebody else is using it. So the very definition of the legal term trade secret entails self-help. This is critical that you remember. You only have a trade secret if you took reasonable, affirmative, ongoing measures to keep it a secret. Now, it doesn't have to be perfect. It's like a diet. It has to be sustainable, right? You only have to take reasonable measures, but the law will not protect you from somebody else's usage of this information unless you took such affirmative measures. So just for example, if you wake up one morning to discover that your former partner is using some information you developed in the marketplace, in order to have a chance to either stop him or her from using it or recover damages for that use, you will have to show that previously to this unpermitted use, you recognize this information as a valuable secret and that you took some measures to preserve it as secret before this happened. If it just happens to be the case that this information remained unknown to the public, but not due to any affirmative measures you took, you're going to have a problem. And I've seen that so many times, time after time, with clients who never took the time to actually identify what do I consider a secret. And we're going to talk about exactly how you do that. But suddenly some company in India is using this information and they go, oh my God, I have a claim. They're making millions. And nobody ever actually thought, oh, this is a secret. That's a problem. You don't discover, this is just the same thing put differently. You don't discover that you happen to have a trade secret when somebody else is using it. You have a trade secret if you made a thoughtful, affirmative, ongoing efforts to identify and preserve the secrecy before that happened. Again, we're going to talk about those measures in a few minutes. Now, let's assume that you have a trade secret, that you met the initial conditions and you have a trade secret. What kind of protection do you get from the law? The law only protects against misappropriation, and that too is a legal concept. And the definitions of the federal and the state law are slightly different, but the gist of it is the same. Trade secret means acquisition of a trade secret by some improper means, something bad. It's not, so let's give an example. What misappropriation? Obvious examples. Theft, bribery, breach of an NDA or a confidentiality agreement. Those would be improper means. More importantly, what is proper? Licensed use is obviously proper for the duration of the license, right? Because you gave somebody permission. It may switch to the improper category, if they continue using it after the license expired. So that's one reason why you need to be on top of when your license is expired. Discovery by independent invention. If somebody is as genius as you independently, that's perfectly fine. Reverse engineering discovery is perfectly fine. So the Coca-Cola formula is one example. And discovery in the public domain. So if, for example, you took reasonable measures, but through some inadvertent happenstance, information leaked to the public domain, and some third party that has no duty towards you uses it, that's your problem. You're not going to have protection. So inadvertent disclosure is probably your biggest risk, and we'll talk about it in a minute. I'm not going to go into the legal issues, but generally, if you do have a trade secret and somebody did misappropriate it, and you want to go after that person in whatever format, you may be able to get an injunction, so to stop them from using it. You may be able to recover damages. It may be a violation of the Trade Secret Act on the federal or state level. It may also be a breach of contract claim if that person is a party to say an NDA with you or a confidentiality agreement. There's some other causes of action we're not going to talk about, but generally, this is when you will have a claim. So what are those reasonable measures that you have to take? We're going to talk about it in three parts. The first, and to me maybe the most important one, is how to identify your trade secrets with particularity. The second is how to tailor a practical plan that you can sustain, and that will be very specific to your business. And the third is the need to execute consistently this plan and have a record. This is the lawyer in me talking about evidence. We'll talk about it in a second. So let's talk about number one, identify your trade secrets. You must identify your trade secrets with particularity. I can't emphasize this enough. You cannot, when you think about your trade secrets and when you think about how am I going to, what kind of record do I have? How do I establish what my secrets are? You cannot possibly think generally about categories or type of information. It has to be very specific. You can say all of my computer code or anything that I have in the business relating to gene expression. No, it has to be something specific. This particular plasmid that I developed in this particular way is a trade secret. This particular code, this particular piece of code is a trade secret. And that's, the scope of the secret and the type of secret is obviously different from business to business, but that's important not to overreach. Again, think about how you can identify your trade secret in the way that doesn't embrace any public information. So you have to be modest about it in order for it to be actually protectable. Let's talk about something that's really a hot topic in the law now, and that's, do you keep a list? You know, it sounds pretty straightforward. If I have to identify my trade secrets, I'm going to have a list. Can anybody tell me what are the benefits? It's quite obvious. What are the benefits of having a list? Somebody. All right, I will share the, it's very tough. The benefit of having a list is that you obviously have a clear record of what you consider a secret long before any misappropriation happened. And it's worth knowing that there's some new software tools that for a price allow the owner of a trade secret to identify and record and track trade secrets as they evolve, and identify who may access them and the time and identity of anybody who did access them. And that may be a very good thing. And obviously, if you have a list, that is in itself a highly protected trade secret. Now, what are the drawbacks of having a list? Come on, somebody say something. So what are the obvious drawbacks of having a list?
Hi, this is Scott Zentak. An obvious drawback would be someone discovers the list and pilfers all your trade secrets.
Okay, what other? That's good. What else?
Just to guess, if I've written a list, I've kind of implicitly said anything not written on that list isn't a trade secret.
Gold star to you. Yes, it's really hard. You know, obviously, if somebody discovers it, that's a problem, but that's a general problem with our trade secret. Having a list is good, but it's really hard to do. And that's why most people don't do it. It may be very doable for you, but it may not. It's hard to maintain because trade secret may change and evolve and be modified during over the years and during time, and then you have to be on top of it. And that's exactly the point that was made here. If you have a list, it will be assumed that it is inclusive, and if something is not listed on it, or worse, was removed from it at some point, there will be an inference that you never considered it a secret. You may be able to overcome this inference through other evidence, but you will be facing a problem. So you need to think about whether you want to have all this information aggregated and compiled in a nice list. But if you do that, it's not a legal requirement. If you do that, it can be a very powerful tool, but you have to be on top of it. Obviously, importantly, whether or not you choose to have a list, you need to have a record of what you identify as a trade secret, again, with particularity. It doesn't all have to be in one list, but you have to have records showing contemporaneously that something that you own is secret and must remain secret. It can be in lab notebooks, it can be in whatever other files, it can be in correspondence, it can be a report to the board, it can be a bunch of stuff. It really doesn't matter. It can be in an email exchange. Ideally, as a lawyer, I would rather have organized records that will show what you consider to be secret, and we'll talk about how you do that. But in many situations, and indeed I think in most situations, it will be a collection of emails and reports and lab notebooks and random computer record. So it doesn't all have to be in one list, but you need to consider what records you have, and then that obviously gets us to the second prong of how you tailor a sustainable plan. So you need to start the plan by assessing your risk. What information are you dealing with, and where are you most vulnerable? So who needs access to this information? Who needs to know it? Is it just you? Is it your partners? Is it your staff? Are they employees? Are there independent contractors? Are there investors? Are there clients? A bunch of outside third parties may need to have access to information. What kind of access? Do they get it completely unencrypted? Do they get it in some other form where they don't have full access to it? Think through those questions, and those are very specific to your business. How fluid is it? Does it evolve? Does it change? It can be as simple as a client list. My client list can be a trade secret. Does it often change? Yeah, if so, I need to be on top of it. Excuse me. The second question that you're going to ask yourself when you tailor a plan is, what are the optimal sustainable measures that you need to take, and again, only reasonable, that you need to take to preserve secrecy? So obviously there can be technological tools, right? And that's obvious. So it can be, limited access to technological information, to files, encryption, password. I'm sure people on this call have a much better idea of what technological security tools exist to limit access to information. You may have physical security measures, especially if you have tangibles, like you have lab materials, whatever it is you're working on. If you have lab notebooks, if you have paper files, if you keep any, if you have computers, servers, whatever it is, not anybody getting into your business can stroll up to anything that contains trade secrets. You critically have to have contractual protections to ensure that people both inside and outside of your organization have a contractual duty to maintain secrecy. They can be non-disclosure agreements, they can be confidentiality agreements. Agreements like that may or may not include non-compete provisions that are a whole different topic we're not going to talk about. But you need to remember that, and this is a general statement that may be inaccurate in certain times, particularly with respect to employees, but assume for the sake of this discussion that nobody has an automatic duty to maintain secrecy. Again, it could be different in the case of employees, and there's all sorts of, or some academic settings, but assume for the sake of this discussion that nobody will have a default duty to maintain your trade secrets, even if they know that those are your secrets. So you need to have contractual measures. Relatedly, training. Your contracts are not going to spell out your trade secrets. An NDA is not going to say, I acknowledge that I have a duty to maintain secrecy of these, and then there's going to be a list of everything going back to our list of trade secrets. Typically, those contracts are going to have generalized provisions like, I'm going to, I have a duty to keep secret everything that is a trade secret, including but not limited to blah, 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 general high level. So just having somebody sign, say, an NDA is not enough. You have to show that they have a reason, they either know or have reason to know what your actual particular secrets are. And that probably requires training. That certainly requires a record of communicating this information to people. And you have to remember that as information changes, this has to be, you have to be on top of it. You have to update it. So there will, there will be some record that those people know exactly what your secrets are. And again, it's way too detailed to cover now, and we have to be done in a second. So I'm gonna stop there. Again, inadvertent disclosure is your biggest risk. I can't tell you how many times I've seen situations where a customer, relation tech, or a license manager communicates with clients or even potential clients or competitors by email, and just kind of spits out their stuff that you're like, oh my God, I can't believe they wrote that. And whether or not that is a problem depends on how strong your plan, your execution of your plan is. Did you take reasonable measures? Doesn't have to be perfect. If you took what court considered to be reasonable, that's not I don't think impossible, just reasonable. Inadvertent disclosure may not be the end of the world if the person, say just for the sake of discussion, your license manager gives information to a client that should not be communicated, but that client has an NDA, then that's probably not going to be a problem. The third one is consistent execution, and that is key. Again, you can have the perfect plan, but you don't keep on top of it, and you let it go and you neglect it, that can be worse than not having a plan. Having a plan or having a list and having records and having training and then just stop doing it infers that this information is no longer secret. So you must put together something that's pragmatic and sustainable for your business. And you really have to have records. You really have to make sure you keep thinking about it. It's not enough. You have to have some paper trail. So that is it. I realized that was super high level. So let me know if this was a complete waste of time, and if anybody has questions, I'm happy to answer.